right here in Daytona Beach, born and raised right here in this particular zone.
Hmm.
So I have been here. I won't tell my age, but
Okay.
at least a half a century I've been here in Zone 5, working, supporting the community and going to school, attending the local public schools. I attended Westside Elementary. I attended Holly Hill Middle School, and then I attended Mainland High School where I matriculated from.
Hmm. Now, with some of the recent changes in all of our zones due to redistricting, your zone has changed a little bit. Can you tell us now a little bit about the geographic area of Zone 5?
So, some positives and negatives. So we're going to lose some places that are very dear to me. I'm going to lose Madison Heights, which is a community that I truly have grown to love, and it's been a labor of love, revitalizing the community. So we're going to lose Madison Heights,
Mm.
but we are going to gain all the way out. If you go down LPGA and you turn right on Clyde Morris, we're going to go all the way down to the line, right till you hit Ormond Beach. So right across from the hospital right there, all of that we're going to gain.
Okay.
We're going to gain some areas out going towards Williamson. The core of the zone, which is your Derbyshire area, is going to stay the same. We're going to keep suburbia, and we're going to stop at Nova Road. And over by Jimmy Ann, we're going to maintain Jimmy Ann. And we're going to pick up some areas out by Tanger Outlet. So Tanger Outlet is now going to be a part of Zone 5.
Right. So it's a pretty big zone. And I think you're going to have something like, and I forget the exact number of residents, but it's somewhere around 12,000 or so that'll be in your zone now. So
Yes.
looking at your zone, what are some of the things in Zone 5 that still give you some concern?
Definitely growing pains. So we're having some growing pains. And then we're having some issues where Zone 5 is a homeowners zone. So there's not a lot of area to put actual businesses here in Zone 5. With the growth, hopefully that will change. There will be some areas where we can have actual businesses in Zone 5. That's always been a challenge, not having actual businesses. I think we've had a couple stores here and there, some gas stations, but that's pretty much. But in the grand scheme of things, having actual businesses where people can come in and say, my business is in Zone 5, that's been some challenges for us. So definitely Zone 5 is one of the older zones. Now, when I grew up here in Zone 5, we were considered the Beverly Hills zone. So we were the suburbs. We were the GE homes, which were the homes that GE built for their people who worked at GE, and my mom worked at GE.
I was going to say.
So that's how we got a GE home.
Right.
And so now we've had the issue where we have those homes, they're older homes now. So helping people to maintain those homes so that they still look nice and they still shine like new, although they are not new. We have some issues with a little uptick in crime, and so we're going to be working more forcefully with the police to deal with those issues.
Okay. And so let's flip from the concerns that you had about Zone 5 to some of the positives. What has made you most proud to have been representing Zone 5 so far?
Absolutely. Just could not be prouder of this zone, considering when you go from here watching this zone to a full-grown adult watching this zone. So in the core of the zone, almost every street was paved. Something that has not happened in decades. So extremely proud of that. Extremely proud of the growth in our schools. We have two elementary schools here, and they're growing tremendously. They're working hard. Their grades are improving. They've got great leadership, and being able to go in with the schools and partner with the schools, because strong schools build strong communities. So before, we didn't have as much of a relationship with our schools. It was kind of, the schools are county, so that's not our business. We don't put our nose in that. Now we know that the city has to be just as invested in the schools, because when people come to live in the community, they choose what school. That's based upon what the grade of the school is, how well the school
9:03. I hereby call to order this session of the Special Magistrate proceeding for the City of Daytona Beach on May 27, 2025. I believe everyone may have seen that there is an agenda. Is it posted outside?
Yes.
Okay, we have 7 matters today. And before I go any further, my name is Robert Riggio. I am the special magistrate who is going to be hearing these cases. Just so that you're aware of the procedures that we follow, the city, the inspector who is handling the matter will come forward and stand at this lectern that is directly in front of me and provide the particulars of the particular case. The respondents will be standing at that lectern over on the other side of the table or bench or whatever right there. And if I would appreciate if when you come up, if you are the respondent, if you could be sworn in. Testimony here is taken under oath. And once the inspector gives his presentation as to the particular matter, you will then have an opportunity to respond and provide whatever arguments or information you feel is essential for me to make a determination on the matter. Also, the city attorney will be making presentations during the course of these matters as well. Okay, the first thing I would like to note is that case 7, which was continued from last week because the attorney who was handling that was also ran over on a hearing at the courthouse, and we'll be hearing that matter first. That's case 7, RTL 04-2521, Deanna Nicosia and Sylvana Nicosia. Okay. Are there any other further announcements?
No further announcements.
All right. I have approved the April 22nd, 2025 meeting minutes and provided them to the board clerk. We will now move on to the hearing of cases, and at this time I need to have all staff members who will be providing testimony today to be sworn in.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Yep.
All right. So let's get started with case number 7. RTL 04-2521, Deanna Nicosia and Sylvana Nicosia, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 509 Eastwood Lane. Do we have the respondent on Zoom?
Yes.
Okay.
Good morning.
If you could state your name at this time and be sworn in if you're going to be providing any testimony.
Sylvana Nicosia.
Okay. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay. And is Mr. Ford on Zoom?
No, Your Honor. Mr. Ford is not able to come. The same case, unfortunately, except for trial. He has docket sounding tomorrow. So my name is JL, and I am the paralegal here at Ford Law. Mr. Ford wasn't given enough notice to, even try to continue it. He didn't want to do that again. So I'm here so that you guys are aware that she can go ahead and work whatever arrangement with the hearing here, because last time she couldn't do so since Mr. Ford did have her under representation. It's just impossible for him to be at 2 places at one time. on this case, and he did not want to continue it again, given the fact that the client is willing to come to court today and work with Mr. Yates and Your Honor.
Okay. Okay, so I take it that Mr. Ford and Miss Nick, is it Nicosia,
Yes, Nicosia.
are agreeable to not have counsel today present at this hearing? Because
Yes.
I'm willing to continue it if need be. I
Yes.
don't want to compromise Miss Nicosia's ability to state her defenses to the claim that's been brought. But if my understanding is correct, you are basically at this point waiving presence of counsel.
Yes.
Okay. And Mr. Ford is agreeable to that?
He is, Your Honor. Would you like any paperwork from him? Because it was last minute. I didn't want to encompass the staff or anybody over the holiday. Would you like any formal paperwork from Mr. Ford?
Counsel?
No, we're okay. I do want to speak on the last minute. This is continuing from last month. They had over a month. So, and they spoke too. They've been speaking, so I'm not sure where the last minute is coming from, but we don't need any paperwork.
Okay. Well, then it appears we can proceed. So, Mr. Yates, if you can give us the particulars of this matter.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed March 19, 2025, and they were notified the same day. The property stopped actively advertising as of March 21st, 2025. The daily posted rate was $330. The advertisement displayed one review. The check-in, check-out time were shown as 2 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz, do you have anything to present?
Good morning. I'm just here to present the city's position. This is a standard speech that we read at all of these hearings. The city's position is that the beneficial, can you hear me? The beneficial gain to the property owner who is advertising conduct that is prohibited by the city's code is unlawful, pursuant to Florida Statute 162.09, as irreparable and irreversible. The effects of renting property or holding property out as vacation rentals cannot be reversed or repaired. Property is advertised on the worldwide marketing destination that draws people from all over the world for principal special events such as the Daytona 500, Bike Week, and so forth. And properties may also be marketed to draw nearby destinations such as Disney World. The information has long-ranging effects in luring patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. One single day of advertising can potentially book a property for the whole year. These promised days are potentially to the detriment of the patrons and definitely to the detriment of the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspections, proper licensing, proper insurance, and proper taxation required by law. Properties whose staff on-site 24/7 to address any emergency concerns patrons have, thus weighing them against the unregulated short-term rentals who do not have to go through these regulatory safeguards is unfair and harmful to the regulated businesses, the patrons, and the community. The monetary effects of these unlawful rentals is tax avoidance, inadequate insurance coverage, and unfair business competition against lawful accommodations. The transient nature of the rentals limit the means of enforcement typically to identifying the advertisement because by the time code enforcement arrives to the property, the transient patrons are typically gone from the property or claiming a misleading relationship that are often contradicted by the advertised visitors' comments. The community effect is that the transient business used within unauthorized residential neighborhoods affects the density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods. It diverts from traditional and reliable residential norms. There's a demand from the community and the business community to our commission, which has led to the request for a strong deterrent to those that are raking in profits, avoiding local taxes, avoiding zoning requirements and regulatory controls, and are wreaking havoc on residential communities who have also spoken to our commission about these detrimental effects to their community. We have seen rentals go for amounts so much as several $1,000s a week, and substantial fines are the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable and irreversible in nature. And also, given the gravity of the violation, a fine of up to $15,000 is warranted under Florida Statute 162.09, Section 1D. Thank you.
Mr. Yates, anything further?
No, sir.
Okay. Ms. Nicosia, it's your turn now.
Yes, Your Honor. I'm sorry, I didn't know that there were special zonings to doing the Airbnb, and that's why when we received that notice, we immediately taken it off. I don't want any problems with the law, for sure.
Okay. Do you have anything further?
No, Your Honor, thank you.
The city has requested a fine in the amount of $1,000. As the attorney stated, they can seek a fine up to $15,000. In fact, when these cases were first being heard, people such as yourself were being assessed fines of up to $15,000. I have looked at this over the years, and I've seen that there are lesser situations where people, as such as yourself, have violated the statute, but then immediately, when contacted by the city, have responded positively and taken down the advertisement and ceased the objectionable behavior. And the standard fine for that has been now, as I said, for about 2 or 3 years, $1,000. So that's what will be assessed in this case. So therefore, in case number, I hereby find the respondents, Deanna Nicosia and Sylvana Nicosia, in case number 7, RTL 042521, as the owners of the property at 509 Eastwood Lane, Daytona Beach, to have been in noncompliance of Article 4, Section 4.1a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and as such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time that the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes, and that the property has subsequently been brought into compliance on March 19th, 2025, and hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Thank you, Your Honor.
Okay, we will now move on to case number 1. RTL 052526 Svetlana Panpuchkina, Kasina Victoria Senikovic, and Katerina Panpushkina, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1a, and Article 5, Section 5.2.8.2 at 210 Bonner Avenue. If you could please come forward. Okay, if you could, are you, okay. Let's see, where am I? Ms. Penpuchkina, if you could be sworn in by the board clerk,
Will
if
you
you're
be
going to be
speaking-
giving testimony?
I'm a friend of the defendant, and she is a non-English first language person. She's asked me to speak on her behalf, so I would like to be sworn as well.
Okay. Actually, you both have to be sworn in because we're relying on what you're saying, and as she is, that you are properly transcribing or stating what she is going to state.
And can you state your name for me?
Stephen, Stephen, Walton, Walton.
Okay. All right. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Quickly mention, you referred to her as a defendant. This isn't a criminal case.
I
Yeah, yeah,
In these
You're
cases,
dealing with
you're
an
a
amateur.
respondent,
Yeah.
not
A
a
respondent.
defendant.
yeah.
yeah, okay, sorry.
Okay.
Just want to give her the peace of mind that.
Okay. Mr. Yates?
All right, the case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed April 15th, 2025, and they were notified the same day. The property stopped actively advertising as of April 25th, 2025. The daily posted rate was $154. The advertisement displayed 67 reviews. The check-in, check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz?
Good morning.
President, when I read our
Yes, I
position,
did.
Would you like me to reread it, or
No.
the city just asked that our position be read into the record, Your Honor?
Okay. The respondent has agreed that the city previous presentation in case number 7, RTL 042521, as to the matter being irreparable and irreversible, be included in the record of this particular matter. And I always say this, and if you disagree with any part of what the presentation was made, this is an opportune time to make any objections you may have. All right. Do you, city, have anything further?
No, sir.
Okay. Ms. Penpuchkina, do you have anything that you would like me to be aware of?
If I may, sir. Svetlana is a citizen of the United States, but not first English language person. Recently divorced with no enforceable alimony arrangements. She is to make what income she can from Uber driving and attempt to establish short-term rentals as an income source. Her cultural background did not delineate restrictions on property usage. While ignorance of the law is no excuse, Svetlana was given to understand that Airbnb was permitted as long as it was a shared residence, and indeed that structure is divided. Such, I have been now informed, is not the case. In her further defense, it appears that short-term rentals are permitted a short distance from her house, although this is because of it's in another jurisdiction. When notified of the violation, she ceased and desisted as quickly as possible. Bike Week was approaching, yet she readily complied in spite of prospective earnings potential. The house has been sold. There's no possibility of reviolation. In summary, her violation was inadvertent, and she complied as quickly as possible once notified, and the stipulations were understood. She would appreciate the magistrate would take these circumstances into consideration when deciding the outcome of the case.
Okay. All right. Does the city have any response with respect to the statements made by Mr. Walton on behalf of Ms. Penpuchkina?
So we are sympathetic, and we are sympathetic to all of our respondents, but as policy, we have to stand with our standard, because if we deviate from that, it gets into deferential treatment, which we could be sued. But we are sympathetic, and we appreciate that you complied as quickly as you did.
Thank you.
I'd also point out that all rentals, and correct me if I'm wrong on this, will require some type of permit or business license from the city.
Correct.
And that should be step one. And at that point, you find out that the particular use that you have in mind, such as I suspect on the property that you had, you could have had a long-term rental, but short-term rentals, you would be told immediately upon applying for that that you can't do it. And unfortunately, it's pretty much similar to most all cities operate that way now, in terms of trying to regulate these types of uses. And again, as the city has said, I try to treat everybody the same way. And the city has asked for 1,000, as they did in the previous one, for someone who responded quickly, and I feel that's appropriate in this matter as well. So I will be assessing a fine of $1,000.
Okay, thank you, Your Honor.
Okay.
If I might add, is there, if the city could explore a way to be proactive in advertising to the general public that there would be some form of paperwork or zoning that might be needed, that might...
Yeah, and I'm currently reaching out to Airbnb and Turbo and all those rentals. We are working on it, but it is posted on our, I believe on our this website. It's posted on our.
That's fine. I just wanted to try to avoid. And if I could compliment Mr. Yates, when I had questions, he was more than forthcoming and treated us very fairly. So, good.
I would just add, I've been hearing these matters for, I think, almost 7 years. And I have tried my best to get the word out. We've had realtors appear before us and to speak to their organizations. I know every now and then you see something in the newspapers, although newspapers are something of the past. And you know, I can't. It's a violation of the code, and that should be the first thing that when someone is going to make use of a property in a way other than for what it's zoned for, to take a look and see what is required. And the planning staff down in this building, it will certainly be more than willing to work with people to find out what it is you can and can't do.
One quick question. The house has been sold. The maximum of $15,000 was held in escrow in the event that this did not turn out as well as it has. What is our next step to getting the fine paid and the rest of we obviously want to release the rest of the funds?
You can contact Mr. Yates, but in essence, this is a lien on the property. You can either pay it or the person who purchased the property can pay it. You don't need to pay that today.
Okay, well, we'll have this settled.
Mr. Yates can explain further.
Once the order's signed by the judge, you will get the instructions for how you guys can pay it immediately, but you can't pay it until the order's signed, so it'll be next week.
Okay, and that will come via email?
It'll come via U.S. mail to the what you guys have on file, and I tell you, you can also contact me via email, and I'll make sure I get it to you that way too.
Thank you very much. I appreciate it.
Okay. All right. Therefore, hereby find the respondents, Svetlana Panpushkina, Kasina Victoria Senikovich, and Katerina Panpushkina in case number 1, RTL 05-2526, as the owners of the property at, let's see, 210 Bonner Avenue, to have been in non-compliance of Article 4, Section 4.1A and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time that the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes. The property has subsequently been brought into compliance on April 25th, 2025, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, And if for any future repeat violation, a respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. All right. Case number 2, RTL 052527, Maria Martinez, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 524 Rebo Avenue.
Good morning, Your Honor.
Good morning. If you could state your names, and are both of you going to be testifying?
I'm David Guerrero, her son. She doesn't speak English primarily.
Okay, I probably need, since she will be telling you things, that you both be sworn in, so that what you tell me is ultimately also considered part of the testimony that is given under oath.
Can you state your name again?
David Garay, David Garay.
Spell your last name one more time for me.
Garay.
Okay. Thank you. State your name.
Maria Martin.
All right. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, and if you need an interpreter, the city can provide one, but if you're interpreting for her, is that correct?
She prefers if it was with me.
Okay. All right, well then, Mr. Yates.
All right. The case before you is a zoning violation. This case was field generated. The property is zoned SFR5. Other accommodations than short-term rentals are not permitted in the zoning district. The violation was first observed April 16, 2025, and the property stopped actively advertising as of April 18, 2025. The daily posted rate was $135, and it displayed 9 reviews. The check-in, check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is seeking a one-time fine of $1,000.
Oh, wait, let you translate.
Que va a estar están buscando mucho de $1,000 y que tiene evidencia del Airbnb y eso. Entonces,
Were you present earlier when I made my speech?
yes.
Would you like me to repeat it, or is it okay if it's read into the record?
It would be okay if it's read direct.
The city asked for our speech to be read into the record.
Okay. All right, the respondent has agreed to incorporate Ms. Diaz's presentation regarding these fines being, or these types of matters being irreparable and irreversible as made in case number 1, RTL 05-2526, and this should be incorporated into the record. Her statements in that matter relating to the irreparable, irreversible should be incorporated into the record of this particular proceeding. And just so that you're aware, the standard code fines are much lower, but since these are deemed irreparable and irreversible, there is a statutory provision that allows in those circumstances to the for the amount of the fine to be elevated.
Okay.
Or higher. Okay. All right. Mr. Yates, anything further?
No, sir.
Ms. Diaz, anything further? No. Okay. Mr. Gray.
I would just like to add that we were unaware of the zoning laws, and as soon as we were notified of our violation, we took quick action to take down our Airbnb siting.
Okay. Well, that's taken into account. As I said earlier, the fines used to be $15,000 for these matters, and we have backed it down, and the city has been willing to do that down to $1,000. But that seems to be what works at this point. So therefore, if anything further?
¿Algo más quiere hablar o no?
No, que I'm sorry.
Okay. So therefore, I hereby find the respondent, Maria Martinez, in case number 2, RTL 052527, as the owner of the property at 524 Rebo Avenue, to have been in noncompliance of Article 4, Section 4.1A, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner in a damaged surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes, and the property has subsequently been brought into compliance on April 18, 2025, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
All right. Thank you very much.
Okay. Our next case is a Zoom case. Gentlemen, do we have the respondents, the Seagrass, on Zoom? Yes. Okay. Can you hear me?
Yes, sir.
Okay. Case number 3, RTL 052528, Paul U. and Alberta A. Seagrass, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.A, Article 5, Section 5.2.8.2 at 108 Lakewood Village Circle.
We are the ones that are leasing the place currently,
Okay,
and we would like to talk.
okay. If you could provide your name and address, and you will have to be sworn in too if you're going to be providing testimony.
Charles Healy, Heley.
Wenjing Zhang, Wenjing, last name is Zhang.
Okay, can you spell your name one more time for me, slower?
Me?
Yes.
Wenjing. And the last name is Z as zebra, Zhang.
I believe it's the property manager.
Okay. The owner.
Okay? Did you,
On Zoom?
ma'am?
My name's Jessica Foster. I'm the broker of Blue Palm Property Management, representing the owners.
Okay. I suspect there's more to this than I'm currently aware of from the little blurb that I have in front of me. So, Mr. Yates, if you could.
They gotta get sworn in.
Oh, have they been? Has Miss
I haven't sworn any
Foster?
of them in yet.
Has she been sworn in yet?
No.
Okay. Ms. Foster, are you going to be giving testimony?
Yes.
Okay. Then if you could be sworn in.
All right, if all three of you can raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
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 Thank you.
Okay. Mr. Yates.
All right, the case before you is a zoning violation. This case was field generated. The property is zoned PDG. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed April 24, 2025, and they were notified the same day. The property stopped actively advertising as of April 24, 2025. The daily posted rate was $77, and the check-in, check-out time show as 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz.
Were you present earlier when I said the city's position?
Yeah.
What about you, ma'am? Were you present earlier when I read the city's position?
Yes, ma'am.
Okay. Are you amenable to us reading this into the record? The city requests, Your Honor, that our position be read into the record.
Okay. One thing I just need to be clear on, Ms. Foster, are you speaking, have you been given permission to speak on behalf of the respondents, the Seagrass?
Yes, the email was sent to Ms. June.
Yes,
Barnes?
I have a copy
Okay.
of the email.
Very good. All right. Then I will incorporate Ms. Diaz's statements regarding this violation being irreparable and irreversible into the record of this proceeding. But again, as I said earlier, if you take exception with anything that she said, you also have an opportunity to provide your argument in opposition. Okay. First, I understand Mr. Seeley?
Healy.
Healy, okay. That you are currently renting this property?
Yes.
Okay. And I'm trying to understand, I don't know who, Ms. Foster, you're acting as a broker? Are you involved with the rental of this property?
Yes, I'm the broker of Blue Palm Property Management, which is the management company overseeing 108 Lakewood Village Circle.
Okay. Well, if you can explain to me what the arrangements are.
Sure. So the people who are there in the courtroom are the tenants at the subject property. The Seagrass are the owners of the property, and they hired us, Blue Palm Property Management, to manage the long-term rental at the property. The Seagrass were notified that there was a short-term advertisement or an Airbnb posting for the property. We reached out to the tenants who told us that they had posted the unit for short-term sublet. They were the ones that interacted with Mr. Yates. They told us that they had removed the posting the same day that they were notified that they were in violation. We couldn't find the posting, but we did serve a 7-day notice to cure anyway, just to be sure that everything had been removed. They were in violation of their lease because no sublets are allowed per the lease agreement. We notified the Seagrass that had been handled and that the posting had been removed from what we could tell. Mr. Yates did confirm that it had been removed, and then we were notified of this hearing. So Paul and Alberta Seagrass asked us to appear on their behalf because they do not live in the area and were not available. That's everything that we know about the situation. It was not our posting and it was not the posting of the owners, but it had been posted by the tenants. We were informed by the tenants that nobody had ever rented it. They also informed us that they tried to remove the posting previously and were unable to, but somehow the day that they were notified they were in violation, they were able to remove it. That's everything we were informed of.
Okay.
Your
Ms.
Honor,
Diaz, do you have a
Yes.
question?
When did the tenants first notify you about this potential sublease?
The tenants did not notify us. The owners notified us because they received, I guess, a violation letter from the city. We never saw it. It must have been sent directly to them. They informed us on May 1st.
So
The 7-day notice to cure was delivered on the same day.
So you weren't notified of this potential sublease until we put them on notice of the violation. Is that correct?
The owners informed us, not the tenants. When we reached out to the tenants,
When were the owners, can you speak to when the owners were first notified of the potential sublease? Was it before or after we served notice of the violation?
after.
Maybe I can ask you guys, when did you notify the owner of the property that you were going to do this?
They did not. They did not notify the owner or us. We reached out to them because we were communicated with by the owner on May 1st. The owner reached out to us, said they had received notification that there was a short-term listing. It was not our listing, so we reached out to the tenant. The tenant informed us that on April 24th, they were notified of the violation and removed the posting at that time.
So I'm going to just explain legally the way we do these things. The fine is posted on the property, not an individual person. So if you are fined today, it's going to be on the property that's owned by your client. And it's up to you guys how you want to handle that afterwards, whether you want to increase rent or anything. But even if they did it without notifying your client, unfortunately, the city's position is still the $1,000 fine on the property.
Yes, we understand the owner of the property nor the property management company was aware of what was going on. As soon as we found out, we did serve a legal 7-day notice to cure, and we have informed the tenant that it was a direct lease violation, and any fines applied would be their responsibility per the lease.
Okay.
I'm just here representing the owner to inform the court that the owner had no idea of any of this, nor did us as the management company until well after the fact. We do also acknowledge that Mr. Yates has been very available and amenable to answering all of our questions, and we appreciate that.
And we appreciate you. Thank you so much for understanding and working with us.
Okay. I have a question. Since this property is being rented out, does it currently have a business tax license for the long-term rental?
Yes, sir.
I believe it does, yes.
Okay. All right. Well, this brings back some matters from many years ago where there were some folks down in Fort Lauderdale who were trying to evade the prohibition on these vacation rentals by setting up straw man tenants. And the problem here is that I understand, I'm not doubting anything that you're saying, but short of a full-blown trial and depositions and discovery, you're left with a situation where someone tries to circumvent the ordinance through a roundabout procedure, and that, as I recall at that time, and Ms. Foster, I think you kind of see where I'm going. That there will be, it's going to be a fine that's levied. At least
Can I explain the situation?
Well, just in 1 second. I'm not going to go any further with that. Yeah, why don't you explain your situation?
Basically, I'm a student at Riddle. I had an internship lined up with a company called EMRO, but they were located in Miami and only going to pay minimum wage. So I obviously am not going to do that. So, but she posted the Airbnb listing, but what she did is she blocked all the dates off so no one can actually rent it. And even before that, if we were going to sublease it, which every Riddle student does during the summer, if you just go on the Facebook parent group, there's literally thousands of like 3-month-long listings just for the summer, or summer A, summer B, which is 2 months. Anywho, we didn't list it or we didn't get any rentals at all. No money was made. And I also believe we did not break Article 4, Section 4.1.8, and I also believe we did not break Article 5, Section 5.2.A.2, and I can explain why. So basically what Article 4 says is no land within the city shall be developed except in accordance with the zoning district regulations. Why we didn't violate it is because we didn't develop the land. We posted online. No actual land use change occurred. No rental business was operated on the property, of course, except for the long-term lease. And posting is not development, it's speech. And for Article 5, it regulates other accommodations, which includes rental units intended to be used by transient persons or tourists for overnight or short-term lodging. Here's why we didn't violate it, is because the property was never used by transient persons. We had 0 guests, no overnight lodging occurred, and we didn't operate other accommodations. We posted an ad. The regulation applies to actual use, not potential use. And I have some more things I'd like to say. we respectfully request dismissal of all charges against us. The facts are simple and undisputed. We posted a property listing on Airbnb, but never rented to anyone. 0 guests stayed at the property. 0 income was generated. No rental activity whatsoever occurred. When the city first contacted us about this listing, we immediately removed it the same day, demonstrating our good faith and willingness to comply with any regulations. Despite our immediate compliance with the fact that no rental activity ever occurred, the city is attempting to fine us for merely posting a listing online. This enforcement violates both Florida state law and our constitutional rights. So first, let me address the state law violation. Florida Statute 509.032, subsection 7B explicitly states, and I quote, "A local law, ordinance, or regulation may not prohibit vacation rentals or regulate the duration or frequency of rental of vacation rentals. This paragraph does not apply to any local law, ordinance, or regulation adopted on or before June 1st, 2011, end quote. The city claims protection under the grandfathering clause because their ordinance existed before June 1st, 2011. However, the grandfathering protection is limited to what was actually being enforced before that date. The city can only enforce what they actually enforced before 2011, not new interpretations of old rules. Your Honor, the city's 1993 Land Development Code focused on regulating actual rental business operations, meaning people who had paying guests, collected rental income, and operated commercial vacation rental businesses. It never regulated posting, advertising, or expressing intent to rent. The enforcement was against actual business activity, not protected speech. I challenge the city to produce even one case from before 2011 where they find someone for merely posting a vacation rental listing without any actual rental activity. They cannot do so because such enforcement did not exist. Online vacation rental platforms barely existed in their current form before 2011, and the city's enforcement was focused on actual business operations, not advertising. The critical issue here is that we engaged in 0 rental activity, no business was conducted, no commercial operation occurred, no rental income was generated. Under the original scope of the 1993 ordinance, there would be no violation because there was no actual rental business to regulate. By expanding their enforcement to cover posting without rental activity, the city has exceeded their grandfathered authority and violated state preemption law. Second, this enforcement violates multiple constitutional protections guaranteed under the United States Constitution. The First Amendment, commercial speech protection. Posting a property listing constitutes commercial speech, which is protected under the First Amendment. The Supreme Court has established that commercial speech receives constitutional protection, and the government cannot impose prior restraints on such speech without compelling justification. By fining us for posting a listing, which is pure speech activity, the city is engaging in impermissible prior restraint on protected commercial speech. This is equivalent to fining someone for posting a for sale sign when they never actually sold their house. 14th Amendment due process violations. This enforcement violates both substantive and procedural due process under the 14th Amendment. For substantive due process, the city is punishing us for lawful activity. Posting a listing is not illegal. There is no rational relationship between posting a listing and any legitimate government interest, especially when no actual rental activity occurred. The government cannot punish citizens for engaging in lawful conduct that causes no harm to anyone. Procedure due process. The procedure due process violation is particularly clear in our case. We received no advance warning that the posting a listing was prohibited. The city never informed us that simply posting a listing without any rental activity would result in a fine. When the city first contacted us, we immediately removed the listing the same day, showing my good faith and willingness to comply. Despite our immediate compliance, the city is now seeking to fine us for past conduct we had no reason to believe was prohibited. This violates the fundamental principle that citizens must receive fair notice of what conduct is forbidden before they can be punished for it. And the city is treating us differently from similar situated property owners without any rational basis. Hotels and long-term rentals operators can post listings and advertise their properties without penalty, but we are being fined for identical speech activity simply because our possible rental duration was shorter. This arbitrary and unequal treatment violates the Equal Protection Clause. 8th Amendment, excessive fines. A fine for posting a listing when no rental activity occurred and no harm was done to the community violates the 8th Amendment's prohibition against excessive fines. The punishment is grossly disproportionate to any alleged wrongdoing. The fine amount has no rational relationship to the severity of the alleged violation or any harm caused. In fact, no harm was caused because no rental activity ever occurred. I want to emphasize that no actual violation of any rental regulation occurred here. The city's ordinances regulate vacation rental businesses, actual commercial activity involving paying guests, and rental income. Since I never rented to anyone, never collected any income, and never operated any vacation rental business, we could not have violated regulations governing vacation rental operations. To put this in perspective, this is like getting a speeding ticket for sitting in my driveway with an engine running. No speeding occurred, just like no rental occurred. You can't violate traffic laws without actually driving, and you can't violate rental laws without actually renting. The city is essentially trying to punish us for something we might have done rather than something we actually did. This represents a fundamental misunderstanding of what their ordinances are authorized to regulate. You cannot violate vacation rental regulations when no vacation rental activity occurs. And I believe the city changed its enforcement practices well after the 2011 grandfathering deadline. Property owners have reported that the city only began fining people for posting listings without rental activity in November 2020, nearly a decade after the grandfathering cutoff. This represents a new interpretation and expansion of their ordinances that exceeds their grandfathered authority. If the city can fine property owners for posting listings without any rental activity, they're effectively creating a complete prohibition on vacation rentals through the back door. Exactly what Florida state law forbids them from doing. They're using speech suppression to achieve what they cannot accomplish through direct regulation. Courts have consistently held that municipalities cannot expand the scope of their grandfathered ordinances beyond their original enforcement practices. The city's attempt to regulate posting without rental activity represents exactly this type of impermissible expansion. Additionally, the principle of fair notice requires that citizens have reasonable warning about what conduct is prohibited. We had no such notice, and a reasonable property owner would not understand that posting a listing without actually renting constitute a violation worthy of fine. This case represents government overreach on multiple levels. The city has exceeded their state law authority, violated our constitutional rights, imposed excessive punishment for lawful conduct, and failed to provide fair notice of prohibited activity. No rental activity occurred, no law was actually broken, no harm was done to anyone. Our immediate compliance when contacted shows good faith, not willful violation. Justice and the law require dismissal of these baseless charges. The government cannot punish citizens for engaging in protected speech when no underlying prohibited conduct occurs, especially without fair warning that such speech was considered a violation. Thank you, Your Honor.
Okay.
That was a lot of words.
First off, I want. Oh,
Does the city have any response to that?
yes. First off, I want to thank you. I've been doing this for a little bit, and thus far, that was the best argument I've heard. So you did a really good job, and I applaud you on your research.
I watched the last two hearings.
Yeah, this is why I went to law school. This is you make really good points. However, I'm going to try to touch on all of them. I tried to take as many as possible. I'm going to start off with the most important one, though. You mentioned that because you didn't have someone stay there, it doesn't count. Per the grandfather clause, right, our original definition, I'm going to read you the full definition. It's in 509.013. Transient public lodging establishment means any unit, group of units, dwelling, building, or group of buildings within a single complex of buildings which is rented to guests more than 3 times in a calendar year for previous periods of less than 30 days or 1 calendar month, whichever is less, or, emphasizing here, or which is advertised to be held out to the public as a place regularly rented to guests. The latter is a statute. It's a definition that we have prior to that state statute, which was grandfathered in. This is a practice that we have held. We've been sued in 2016. A court has upheld this. Again, it's a very valiant argument that you have made, and I commend you for that. It makes this, exciting for us. And I like it when people are informed and look into it. But on the note of being informed, I can tell that you're very educated. You did the research. I just wish you would have looked at our land development code before you did this.
I just thought it was fine because all the Riddle students all just listed anyways, but I didn't know it was.
I understand. And we're working on trying to, but Mr. Yates is one person and he has to handle all of this. But also, as Florida statute, federal statute, and a lot of case law, right? Notice posted within our Land Development Code and Florida statute is enough notice per due process to let you know of our rules and regulations that must be adhered to. And then you mentioned previous case of 2016 when we were sued, we were upheld. And then commercial speech. Commercial speech is protected speech to an extent. It's limited. It's not the same as going outside and saying, you know, I believe in our Second Amendment, right? That is protected speech, which the prior restraints are more applicable to. Commercial speech is speech that we can limit, and courts have regularly upheld it. The way we're doing it is lawful. And then your last one was deferential treatment. In my position, if you recall, I'm going to read you a little portion of it. The reason that it's not deferential treatment is because these other businesses are doing what you are not. They have staff on site 24/7 to address emergencies, which is the reason that this happened. We had community guests during the truck, I think it was one of the truck events, that destroyed a neighborhood. And people were livid, came to us saying that residential neighborhoods should not be rented short term because these people don't care, right? You care because you were there for 3 months, you had a lease, right? You had responsibilities that these weekend getaway people do not. They don't respect our neighborhoods or our communities. In a hotel, it's contained and there's staff there 24/7 to address community concerns, number one. Number two, proper licensing. I believe you probably don't have a license or pay business tax for the short-term rentals. Number two, proper insurance if anything were to have happened. Proper inspections. I'm sure Mr. Yates didn't inspect this property prior to your listing. And I'm not here to chastise you. I'm just trying to express the reason that this matters to us. We're not finding you $1,000 because we're trying to harm you. It's one, because if we don't, it is deferential treatment if we're treating you differently. You mentioned the other Riddle students. If he is one person, he's working on it. But if we were to let you go and then find these other people who did the exact same thing, then we would be sued for deferential treatment. And do you have any other questions? Because I'm happy to clarify it. And I really appreciate the valiant effort that you made.
No.
Thank you.
Okay. I'm just have a few questions regarding what I see as the standing issue. This is a matter against Paul U. and Alberta A. Segrist.
But I understand. As a matter of due process, I just wanted to have him be heard.
And I'm hearing a lot of arguments that are being made that are not, you are not a representative of the landowner. The property owner is the one who is
I understand,
technically
but we're going to be the
before
ones
us.
paying the fine at the end.
Well, I understand, but it's
I feel like I should at least try and get the fine down than just.
You made a valiant effort. The best I've seen.
okay. I've heard a lot of the things that you have stated before, and there were very good arguments made on behalf of the city. And one of the most important one is the holding out for rent. You don't have to actually rent something. I think there's a state statute that the city has adopted, as I recall, that says the mere holding out for rent constitutes the action of renting. And that was raised some years ago. And so I understand your arguments. And what does the city wish to do with this matter?
Be consistent with our policy. I believe that we want to hold on $1,000.
Yes, sir.
Okay.
There was no damage, no noise, no traffic, no. Can we lower it at all?
Sir, could I speak on behalf of the owners who are the people
I was going to
who...
ask if you had some comments to make, so please do.
I do. First, Paul and Alberta Segrest did not give permission for the tenants to appear. They did so on their own accord. I would like it noted for them. They do comply with the requirements of the city. They do have the proper licensing They have hired a professional management company to handle the property long-term for them, and they were unaware of the tenant's actions, specifically because it's a direct violation of the tenant's lease, regardless of what any other renter in the city of Daytona or in Volusia County does. The lease specifically cites that no subletting is allowed and that the only occupants of the property are those stated on the lease as the tenants. This was not something that they came to the property manager with and said, I'm going to be going away for an internship. I need help getting out of my lease. I need anything. This was not brought to us as property managers. It definitely was not brought to the property owners. The property is owned by Paul and Alberta Segrist. They are the only people who have the authority to rent out their home. Never anywhere in the lease or verbally were the tenants approved or allowed to post the home for any sort of rental or sublet. If they would have come to us, which I wish they had, we would have told them it was not allowed and that they'd have to seek alternate arrangements for this internship. We understand that nothing occurred as far as somebody coming in and subletting or no monies were exchanged for this short-term rental, but it is a direct violation of the homeowner's rights, and it is a direct violation of the lease. That being said, the Segrists understand that because they own the property, they are responsible for any damages, such as this $1,000 fine. I know there's probably nothing that can be done to prevent them from absorbing this. We will handle it separately with the tenants per the lease. This is covered. But I would just like the court to understand and the record to reflect, Paul and Alberta Segrist did nothing wrong. And they are going to be fined because of the actions, the unauthorized actions of tenants in their property. And I would just ask that there is some leniency, if there could be any, for them and what they've had to endure.
What does the city have to say?
Yeah,
It
unfortunately.
doesn't change our recommendation.
It's a matter of, like he mentioned, established policy. We can't deviate from that. Your Honor has the discretion to whichever decision you feel is right, but our stance is firm to keep it consistent and fair to everyone here.
I sense there's a certain amount of passing the buck because under the statutes, the owner, as Ms. Foster has stated, is responsible for what goes on at the property. Although in this situation, the testimony would indicate that the individuals who they turned the property over to engaged in the behavior that was prohibited by the statute. But the statutes, this is a, what do they call that? Where you, passing the buck, so to speak. And so, and this had happened before where individuals attempted to rent out properties to other individuals, and I'm not saying the Fosters did this because of what Ms. Foster had to say, but so that there was no accountability anywhere. And our standard has been, as I had indicated earlier today, that when these cases were initially heard, they were all assessed $15,000. And I have tried to back it down because there has been faster compliance and a lot of situations where that fine may be more than the respondent could pay, etc. But I don't see any reason to treat this matter any differently than any of the others that we've heard today so far.
We didn't actually know anyone could even see the listing because she had it all blocked off, and like there's no dates ever that it was ever actually like available.
The problem, sir, is again, I don't even believe you have standing in this proceeding.
That's fair.
Okay, you are trying to make arguments which actually inure to the detriment of the property owner. And whether or not I'm just not buying into any of it. So therefore, in case, I hereby find the respondents, Paul U. and Alberta A. Segrest, in case number 3, RTL 05-2528, as the owner of the property at 108 Lakewood Village Circle to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. And such violations are irreparable and irreversible because the improper benefit obtained by the owner, damage to the surrounding neighborhood occurs, time the violation occurs, and cannot be undone as provided for by Section 162.091D Florida statutes. Property has subsequently been brought into compliance on April 24, 25, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. Case number 4, RTL 05-2529, Ivan DeFreitas, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2, at 400 Auburn Drive, number 2. Sir, if you could state your name and be sworn in.
Ivan DeFreitas.
And if you'll raise your right hand. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned MFR 40. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed May 7, 2025, and they were notified the same day. The property stopped actively advertising as of May 21, 2025. The daily posted rate was $140, and the advertisement displayed 6 reviews. The check-in, check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $5,000.
Okay. Ms. Diaz?
Oh, yes. Good morning, sir. How are
Good morning.
you? Were you present earlier when I read the city's position?
Yes.
Would you like me to reread it?
No, thank you.
Your Honor, we just asked that our position about the irreparable and irreversible harm be read into the record.
Okay.
Thank you.
All right. Since everyone's in agreement, I hereby order that the city's previous statements made in case number 1, or sorry, case number 7, RTL 04-2521, Deanna Nicosia and Sylvana Nicosia, relating to these types of violations being irreparable and irreversible, and the basis for that determination be incorporated into the record of this proceeding. Okay. Anything further from the city?
No, sir.
Mr. Yates? Mr. DeFreitas?
Good morning.
Morning.
I'm just curious, why is my fine $5,000 and not $1,000?
Good question. Mr. Yates?
It took him 14 days to respond. Due to the fact that it was over 2 weeks, we start to look at enhanced fines.
Okay. Mr. DeFreitas? Ball's back in your court is, why did it take you 2 weeks to take down the...
So the fine was submitted on May 7th. I didn't get the letter until later when I reached out to Yates about the fine, about the violation. I took it down immediately. So I wasn't aware of having to take it down right away. I'm sorry, I'm not very versed in legal matters and what it meant, so I apologize for that. I asked if it could be reduced to $1,000, please, as I didn't know.
Okay. Mr. Yates, is there anything on is this Airbnb?
Yes.
Was there anything on the site that would indicate that the property was rented out?
Yes, there were 6 reviews.
Two,
6.
6 reviews?
Yes, sir.
Well, between the period of...
Oh, no,
May
sir.
7th and May
No. I
21st.
visited the property regularly, and I didn't see any guests during that time period. No, sir.
Okay. And Mr. DeFreitas, did you post the property on May 7th? Or when did you first make contact with Mr.
I posted the
DeFreitas?
property. We first made contact on the 21st when he removed the property. He called me and then removed the property that day. But he was posted on the 7th.
Okay. All right. Mr. DeFreitas, do you live in this area?
Yes, I do.
Okay. Posting is usually what is done when there's difficulty in contacting somebody. Am I correct?
For short-term rentals, we post immediately just due to the nature and the impact on the community and the need to inform the owners as quickly as possible.
Okay. All right. Do you have anything further, Mr. Yates?
Oh, no, sir.
Does the city have anything further? Mr. DeFreitas, do you have anything further?
I just asked if we could reduce it, please. If I was aware that I had to take it down immediately, I would have. Once I reached out to Mr. Yates, he told me I needed to take it down, and of course I complied with that. My apologies for not taking it down right away, as I was unaware.
Okay. All right. I'm trying to think in my own mind. If I got a violation, the first thing I do is contact the city. Is your name on the
My
notice that
name,
you
my
left?
email, and my phone number.
Okay.
Mr. Robert, sorry, Your Honor. I just got a letter that said to come to court, so I figured this would be taken care of at court. So that was my thought process.
Okay. I want to believe you. You certainly seem like you're a believable person. And it would have been much better had you immediately contacted Mr. Yates. And I don't want to start having large gaps or see large gaps start to exist between notification, because if something is wrong, then it's wrong, and it's wrong this every day thereafter. What I am going to do is to reduce the amount of the fine to $2,000. I can't. The other people immediately got on these things and immediately responded. And based on your testimony, and I want to believe you, you don't seem like you're not believable, but it's sort of in that gray area in between. So that's what I'm going to do. I'm going to find you to have been in violation, but I'm going to reduce the fine from what the city has asked for to $2,000.
Okay, thank you, Your Honor.
Okay. Therefore, in case number 4, all right, let me start. I hereby find the respondent, Ivan DeFreitas, in case number 4, RTL 052529, as the owner of the property at 400 Auburn Drive, number 2, to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding the neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.09 1D Florida statutes, and the property has subsequently been brought into compliance on May 21, 2025, and hereby order the respondent shall pay a fine in the amount of $2,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on the subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. All right. Case number 5, RTL 052530, Joanne DeBaron King, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 507-509 Jessamine Boulevard. Ma'am, if you could state your name and be sworn in.
Joanne DeBaron King.
Raise your right hand. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
Yes, it is.
Thank you.
Mr. Yates.
All right, the case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed May 1st, 2025, and they were notified the same day. The property stopped actively advertising as of May 6, 2025. The daily posted rate was $120. The advertised rules showed no smoking and pets were allowed. This property has generated multiple citizens' complaints over short-term rentals. This is also the second violation by this owner at this address, the first being CEB 02-1612 on April 14, 2016. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, and this being the second violation, the city is requesting a one-time fine of $15,000.
Okay. Ms. Diaz, do you have anything to say?
Good morning, ma'am. Were you present earlier when I read the city's position?
I'm sorry, I can't hear.
Were you present earlier when I read the city's position? Would you like me to reread it, or do you, would you?
No, you don't have to read it.
The city requests that our position about this being irreversible and irreparable harm be read into the record.
Okay.
Or in nature.
All
I
right.
might add, I am the poster person for Airbnb. I was the first person that came into the courts. I was sold my house by a realtor. Oh, do I?
Okay, and Ms. King, before you get into that, I have to say for the record that I'm hereby incorporating the city's arguments relating to such violations being irreparable and irreversible, and that these be included within the record of this proceeding. And again, as I've told other respondents, such as yourself, if you take exception to anything that they say, you can also make your statements as well.
Okay.
So if you can continue on,
Okay.
please do.
Anyway, I am the poster person, okay?
Okay.
And I was sold the house by a realtor and told to do Airbnb. Over the years, I have actually helped. I've sent letters in showing realtors doing the exact same thing. As far as this particular case, I'm raising grandchildren. I do not have anybody. I didn't even know that VRBO had an account with me in it, and Kevin pointed it out. He had to send me an email. And it says I'm a property manager. I am not. I invited them into my home. The pictures that he has are from when I listed my house on Zillow or whatever it was when I was trying to sell my house a couple of months ago. He came in. He could show you the pictures of the house as present is not the same pictures as what is posted on the postings. And I explained that to him, that I am not, that was my grandson. Somebody did have, when I was selling my house, that room looked like that because I had somebody staying with me that was my relative, and she moved on after her divorce. I also contacted the Airbnb, and there are several names. Nothing has been booked, but there are several different names that are on there, and I found out that I couldn't even get into the account because I wasn't one of them. And the other thing is my ID was hacked on the 27th of April, and This account was not made by me. I never used it. The only reason that anything popped up is I was on the Airbnb trying to book a place in Panama, and it came up. Kevin even tried to book on May 21st and May 23rd, and it showed up that it wasn't available. There is no monies being exchanged, and nothing is connected to my particular accounts and my name, Joe Tamim, Joe Gori, or whatever it is. None of this has anything to do with me. I'm not stupid enough to go and put my house when I know that he's been chasing after me for 10 years. As far as the complaints go, I believe they were in 2016. Nobody has any problems. I live with my grandchildren at this point. I am raising 2 of them, and there really isn't any room for any of that. I keep a rental license only because the city told me if I don't have a rental license, that if I go to sell my house, somebody else wouldn't be able to use it as a rental. So I pay $280 a year for that. So, and I have the documentation here where my ID was stolen by the company. I've looked at it. Everything is there. Matter of fact, when I found out about this, I was down the city before he had a chance. He wanted, he came in. I was at the vet. The next thing, he said he wanted to come in right away so I wouldn't have a chance to change the room. And I agreed to all that. I mean, I don't know what else you need. I know, Kevin, you've been chasing after me for so long. Matter of fact, I have given you plenty of leads. So,
Okay.
show the pictures of what you were in my house.
All right.
For sure.
Mr. Yates,
Yes, sir.
how do you respond?
The photos are clearly of her house. They clearly match. We get multiple complaints about this property. Oh, go back one, please. Go back to where it's booking. So you can see there was a booking open. There's the May 21st and May 23rd for 2 guests. It is open. It is bookable.
It is not booked. Try to give me a website to get on that company. So somebody is putting it up there, and when somebody went to book on it, they weren't able to. There's history.
As I stated, it is bookable. You saw the booking page right there for those dates. It is that home. I was able to go in and get photos to verify it being the same one. As you'll see,
Go ahead, show me
these
the pictures of
photos,
where you were.
you can see the murals match right there. The TVs match. Keep going. We can see it has the same door. We can see it has the same back, the backsplash of the tile there. This is the same room. This is the same home. Keep going. And you'll see once again, same tile on the floor, same position of the window, same door handles, same style of wooden door. And then these right here, these are from Realtor.com and from her ad. And as you'll see, same very large, very unique piece.
Exactly.
So
Realtor.com.
this is...
Is Realtor.com
No.
a
All the
short-term
photos
rental?
except for, okay, all the photos on your right side are my photos. All the photos on the left side are Airbnb, except for that one right there. That one is Realtor.com and Airbnb.
And when you came to my house, none of that was there.
All of this is there.
No, the furniture's changed.
No, most of the furniture is the same.
Show me.
Yep. As I said, this is clearly the same home. It's
It is.
being
That
advertised.
picture is with that, but it
Ma'am,
comes
excuse me,
also-
ma'am. Please let me speak.
Let him speak. Please let him finish, and you'll be given an opportunity to respond.
It's clearly the same building. It's clearly for rent again, and it's clearly generating citizens' complaints. This is not her first time, so we ask that we do have a finding of $15,000.
I'm asking when the complaints were. The only complaints you could be getting is from my grandchildren having parties there with their trucks, because I've got the house filled with kids. And if there is a complaint, I'm entitled to knowing who's complaining, am I not? Isn't that the new ruling?
My
for-
recollection, that's the statute says that you're entitled to know who complains.
We have no problem producing a list of
Yeah,
complainants.
okay, please do.
I'm not going to go through it right now, ma'am. unless the judge would like me to.
Additionally, in addition to complaints, I have reached out, what this company is called?
VRBO.
Well, first I did Airbnb,
Yeah.
and then I reached out to this company. And I just want to remind you, ma'am, that you are under oath. It's the same as court. If you lie under oath, that's considered perjury, which is a crime. If I were to get a subpoena from this company, your social security number or someone in your, would not be on this account.
Right here, I can show it to you.
No. You're testifying today.
That no monies has come through, that I have not. And you can go and call whoever, and I'm showing you here, my ID has been compromised and.
When was this filed?
The 27th of April. This has been the
This-
new one, okay?
This-
This has been going on. February 28th on 24.
Does your ID have
is when
your
it
social
started.
security number on it?
Yes, this is what's compromised on it. And they have offered to put on there the, I don't know, the monitoring on your crediting. And as far as VRBO, didn't use them. And as a matter of fact, my opinions on the short-term rentals, after seeing what happens to, and as far as the short-term rentals, I agree that if everybody rents out, it would be party central. I don't agree with that at all.
Yeah. You know,
And I see that realtors are still selling houses, saying
these
that
are
you can
irrelevant
do it.
arguments. What other people are doing is irrelevant to your case.
To do what?
What other people are doing is irrelevant to this case. Like I mentioned in the previous case, we have one person. We're doing the best that we can with our resources.
Yeah,
right?
I get it. I know 'em.
We're also not forensic accountants to do all of your accounts. You know,
I have
who's
all
to
the
say?
names listed of the
Okay.
people that were there.
So I just want to clarify for the record under oath that if we were to reach out to this company and they were to provide us records, your name and your social security number would not be on this account showing that you received, okay.
There again, it's not active. And he tried to activate it, it's not active.
Just to clarify this document isn't from any sort of credit reporting agency, any
Yeah.
sort of law enforcement agency. This is merely a company that she's used saying they had a data breach at some point. So this is not in any way her filing.
Can I see that?
Yeah.
I thought this was an official
No,
police
she didn't
report
make a police
filed.
I haven't
report
just
about-
got that, don't know anything about it.
So no, she has
And
no.
there hasn't been
Ma'am,
bookings.
excuse me, please let me finish.
Kevin, you came into my house, you bullied me, and you were really upset that
Please,
the room
let
was
Mr.
changed.
Yates finish, and then you will be given opportunity to speak.
I understand that it's frustrating and you're trying to get your point across.
I get it.
And the way this is going to go,
This also says may have
you only have a
included.
chance to talk. But if we continue to have a back and forth, then we have to
I
escalate
get it.
that, okay?
Yeah, Your Honor, I'm just not convinced that.
I can't follow arguments when people are going back
You know
and
what?
forth
I'm not even
like
gonna
that.
argue
So
with
it's
you.
much easier if he states what he wants to state, and then you will be given an opportunity to respond.
I just wanted to clarify that she's introduced no evidence to show that her ID has been stolen. That is a letter stating that there may be a data breach at a company that she used, not that she was specifically affected, but that she should check on her own if she was. So no, there has been, or at least not introduced yet, to show that any ID has been stolen. And unfortunately, the evidence is rather clear that as the pictures match, that is the home. This is a multiple offender, and it matches. I don't know what more.
We've met our statutory and ordinance requirements in terms of standards of proof.
Okay. Mr. Yates,
Yes,
can
sir.
we go through those pictures again?
Yeah,
So
absolutely.
that I can understand.
Okay.
First, let's go kind of slow.
Okay, so as you can see, I put in those dates. You'll see May 21st to the 23rd for booking.
What is, I'm sorry, 420 friendly?
It,
Assuming that means
it says you can
marijuana?
smoke marijuana on the property, yes.
And what is this posted on? Is this VRBO?
VRBO. Okay, and so after I put in my dates, then I click that I want to book this property. Then this comes up. Book it, says it's non-refundable, and it says $352 for the dates, May 21st to May 23rd. I could have paid right then. There are the days being available. Next, please. It just describes it's very close to the beach, close to the Hard Rock, where her house is.
Let's go back one if we can.
Yeah.
It says property manager Joanne DeBaron.
Yes, which is, yeah.
Okay.
Property manager.
Okay. Continue.
Here you see the rules, the pets, the smoking. And go back real quick, you can also see when I would receive a refund today, but if I booked it and I didn't refund by May 7th, there would be a partial, and you can see, so there is a refund policy. There's the host.
Okay.
That is the approximate area. Zoning. All right, so here we have the bedroom that I entered right here, the time and date stamp. That means it's my photo. That's what's on Airbnb. You see, it's an identical dresser.
You had a VRBO, I thought, before.
Yes, this is VRBO, excuse me, sir.
Okay.
So here is the VRBO ad photo. There's my photo I took live on the 6th.
6th of
May.
May. Okay. And you're saying, let's go back a second. I just want.
So you see the mural's the same, and then if you can actually see the design on the dresser on that top piece, you'll notice it's the exact same design on the dresser as well.
Is that a mirror on top?
Oh, it's a TV.
It's a TV, okay, but it's acting like a mirror because it looks like there's a window in the background.
It is. It's
Close up on those dressers. Close up on them.
But the
we don't
dresser.
have an enhanced thing.
The dressers are different.
Okay,
Yeah, these are just
but
little details that don't matter.
So-
We
No, I
proof the
realize
listing.
that, but one is on Zillow and one is on his camera.
No, it's from Airbnb or VRBO. Excuse me. There's no Zillow photo yet. Continue.
Mr. Yates,
Yes.
can we go back to that for a second?
Yeah.
I'm trying to, I see under the TV screen,
Yeah.
there's a big rock. And I'm just
Is it-
trying to make sure.
Oh no, that's an anchor. That's an anchor that's made of shells. It's not there in that photo. It's just a little, you pick up.
Is that some kind of, what is that? Because it looks like a photo or a mural.
It's a mural. Yeah, it's a big mural that you can buy on Amazon and you just paste it on your wall.
Okay, but the murals,
The same.
no, I don't know that they're the same.
That's just a different
It
angle.
looks,
Okay, sir.
the thing with like an eye on it looks the same, but then there's something in front of it on the left side.
Your Honor, they are the same. This picture is from Zillow. This picture is what he took. Somebody was staying in there, one of my friends, and all that stuff got removed months ago. And now my grandson is there. As you can
Let her
see
finish,
in
let her
the
finish.
sloppiness.
Okay, so the pictures are the same. Okay, so there's no
The
disagreement.
mural is the same, yes.
Okay, but you said that one of these pictures is on VRBO.
This,
This.
it's also on Zillow.
That's what I saw.
Okay, why is VRBO, if my understanding is correct, is short-term rental site?
Correct.
Why is there a picture on, is that a recent picture on VRBO?
We do not get dates for the photos. I cannot get a date for that photo.
But is that attached to a current listing?
Yes, the one that she removed.
Okay.
Yeah.
The company's willing to give records. We just didn't have time before this hearing, but I wanted just to refocus us right now. We're arguing about irrelevant things. Our burden was to prove that she advertised or held out this space as a place to be regularly rented to guests. Her name is on the listing and the listing's been posted. Whether the pictures are different new or, it is irrelevant. She posted it, her name is on the listing. I don't believe she's met her burden of proof that her identity was stolen and that it wasn't her. We're willing to subpoena the records from the company.
Kevin also said he was able to book that room, and here comes out the thing where it says it was not available.
He wouldn't have booked it on our government forms. He could have, he just didn't because we don't have the resources.
Property wasn't available for those dates for him to. And like I said, I have been the poster person for this, vacation rental thing for so long, and have turned many people in myself because it is not. I had a place in Seaside that my family just had a
We have
disaster
CIs that
with.
turn in other criminals too. It's
Okay.
not that this is a
Given
criminal
the
case,
amount of
but
the fine that you are seeking,
Yes.
I think it's incumbent upon the city to come forward with a much more detailed case. Okay?
She's admitting those are the same photos. She
She's
agrees.
admitting it's the same photo, but
So, and in
you
her
mind if I-
home, and that it's on a
She's
listing.
also stating that her identity was compromised.
And
And I don't know whether or not how that relates to any of all of this.
Because I'm saying VRBO, I've never put anything on there.
This is a
That I can guarantee you. Airbnb, I was busted on 10 years ago, whatever, I bought the house. And as soon as I found out, when I opened up my thing to book a Airbnb trip to Panama, it came up. I was in his office and I showed him the paperwork. And I immediately was like, what the heck? And it is not there now. My grandson has been living with me for a year, goes to Seabreeze High School, is graduating. And if there has been complaints on me, I'm sure they weren't for any short-term rental, because we have teenage parties in front of my house that I am aware of.
Your Honor.
And I would like to see that list of the people who complained on our baby.
Are you agreeable to sitting down with the city and going through this?
Your Honor.
Because as I see it right now, I would like to know the answers to some of your questions. And I don't think that just, go ahead.
Your Honor, I believe that this is opening the door to a very dangerous precedent where anyone can come here, and I get those letters all the time. I believe everyone in this room has probably received a letter, because legally, even when a company is suspected of a data breach, federal law requires that they send those letters. It doesn't mean that she did. She has no real proof that her identity was stolen, and if we give this credence, everyone can come here and allege that, oh, I received this letter from my bank that I was probably scammed, I didn't post this, and we don't have the resources to subpoena every single case. Those take months to get. To prove that this was the actual person, we would have to get forensics to go through their accounts. Who knows where these money's hitting? I just believe that this argument would open a very dangerous precedent, which she hasn't established. She has one letter from one company that may have been stolen. She didn't find anything. She didn't file anything with the Bureau. She didn't file a police report. She didn't put a credit lock on all her accounts. If my credit was hacked, and I really believe that, I would have put a freeze on all of my accounts with the credit bureau. I would have done a police report. Okay.
But the names
this is not
Joe Tameen. Who is
It's like going into a criminal court and saying,
Those names she's mentioning are not anywhere on the listing.
They're right here.
We don't know I don't know what she's referring to with
I
those.
couldn't get into our
You have
RVA.
said
Those are
that
not
there
a part
are
of my case.
complaints.
Yes. Got them right here.
Excuse me?
Yeah, right here. Absolutely. Here we go.
so public records, you can't release the name, but you can release the date and what the complaint was. The name
the
party,
name.
the people who complain don't read the name. Of
Okay,
the
don't read
people.
the name. Okay.
Just
sorry.
I'm
read
not
it.
entitled to that, isn't that the new law?
You can put
when
you can put a
complain?
you can put a public records request, and they can determine that redactions. But this isn't a criminal case. So this isn't
Okay,
a Fifth Amendment.
It's just a short-term rental came in, complaint of short-term rental on, let's see the date, sorry, give me 1 second. This is the old, May 10th, 2021. There's one. Go to the next one. So
And is it-
it'll be a bit inefficient to do it this way, because I didn't know that we'd need the dates for all of them, but give me a minute.
Well, if that's the case, why didn't you tell me then?
That case was unfounded, and that wasn't my case, ma'am. I wasn't working short-term rental at that point. Another one for 2020. And then, when is this one from?
Again, these are irrelevant arguments. We don't
Yeah.
need complaints. We found a listing with your name, and the address.
But yes, as I've stated, we do have several complaints in
Like
here.
I said, I have people living in, my back house, and I have my grandchildren living with me.
For
I
expediency,
haven't
we'll
been-
redact the complaints for expediency. Our argument rests solely on the fact that there are.
My preference here is, and Ms. King, it said Joanne DeBaron, is it Joanne DeBaron King? Ms. King, would be for you all to sit down and go through these things. Okay?
I think you should just find me the $1,000, give him his satisfaction, and we all go away and put this aside. $15,000, I'll have to get the lawyer, we'll have to go through the whole 9 yards, it doesn't make any sense. Kevin's been after me for 10 years.
Kevin hasn't been doing this for 10 years.
No.
He was, when he started his job 10 years ago, we had a little bit of an incident, and he's been doing a great job with the Airbnb. I've been following. I got the people on Seabreeze, they've been down. There was 187 when he started, and there's 2 left, one that he doesn't know about.
Do you mind if I ask, Your Honor? We have fined repeat offenders previously $15,000 in the past. I'm not sure what makes this case different. For the same facts, we had the same evidence in previous cases. If you want, I could take a recess and I can have my paralegal pull all of those previous cases. But I just don't. I'm just a little bit. I apologize if I'm a little bit, passionate about this. But I'm just surprised because we have done this regularly with this evidence in the past. I'm not unsympathetic, but she knew what the rules were. She admitted to it. But to make this extravagant argument that her...
I am concerned that how many postings are there? There's the VRBO, correct?
That is the only one. Just a VRBO.
Just a VRBO.
Yes.
And this lady has stated that she believes that her account may have been hacked.
Why didn't she do
But
it?
yet she was able to close it the same day she talked to me. And she...
No, I closed Airbnb. I got on there and made sure that was closed. That was what came to your office, and
That's
you showed me
simply
where
false.
the email.
That's a
You had
good
an email.
argument.
Yeah, she literally closed it the day we met. She had control of it. It's more than obvious. She admits that those are the houses in the photos. This is the same evidence that every other person has had when they have been found in non-compliance. So we are simply requesting the same thing that everyone else gets.
Ma'am, if do you have can you briefly summarize your relationship with VRBO as the city has
I
stated?
really don't have one. I don't know how they work. Airbnb is something I've used, and even that has, it's been so long. I've traveled with them. Last time I traveled 3 years to Egypt, I did Airbnb. VRBO, I am not familiar with their platform. It did show up, but it doesn't have, matter of fact, they're asking for my tax ID is not correct.
So what's your explanation for it being taken down the same day he put you on notice? What's the
Because he
argument?
gave me the email to go and find the account, and I called them up and asked them what the hell.
And also, just to clarify here, why would anyone steal your ID to open a hotel in your home? You would never get paid
I
for
don't know,
that.
Kevin, why don't you tell me?
That's my point. The only person who could possibly make money would be the homeowner. It wouldn't even make any sense to attempt to open it up because you wouldn't get the money until the person stays.
But it's never been rented.
Okay, my problem right now is you were fined in...
I was not fined.
Or-
It was brought with the whole.
You said there was a previous matter
It was.
way back when.
Yeah, I was the first person that was recognized as vacation rental, and then it went into
Do you have a date?
387. Sure, we were part of the suing the Daytona Beach for the right to do
And what-
vacation rental.
When would that have been?
2016?
Okay. 2016 to present. Has this lady been cited any other times?
No, but we've had complaints in between.
We've
We
had
just haven't been able
complaints.
to catch her.
So, understand something. You say complaints,
Yes.
but I don't know any of the particulars of the complaints.
It literally, the complaint is, there is a short-term rental at 507. That is the complaint. We have a name with it. If you'd like to look at it, they just didn't want me to announce it in open court.
But we can't legally, I'm not a clerk of court. We don't have the authority to redact and release information. To release those complaints, we would have to put a public records request with the clerk, and the proper responsible party would have to do that. We don't have that authority.
But you're asking me,
Well, then we're removing the complaints. We don't need the complaints.
You're asking me to fine this lady $15,000 based upon a complaint
So-
that
No, based
I
upon
have
the,
no idea what it is.
based upon the ad online. That's what we're asking
So
for.
if you may, I don't have the minutes for all of the months in front of me, but last month we found Opulent Home Healthcare, $15,000, and all we had was the listing and their
Correct.
name on the listing. That's all we had.
But they have been fined repeatedly for something like the last 2 years or 3 years. And there has been testimony regarding what's going on there.
Of
I'm
Mormon.
I'm just having a problem here, and I'm sorry, but right now I'm trying to work my way through this, and what I need facts. And if a court was reviewing it, a court would want to see facts. And I'm not seeing any. I'm just seeing one VRBO posting, which this lady has denied that she made. And the fact is, she said that she's not said that she doesn't use those types of online things, but she uses Airbnb, not VRBO.
Well, if we're willing to continue this, and I'll subpoena this, and then we'll bring it back on, we can subpoena the records from the company, and we'll show that, what she's saying under oath isn't what's going on, and
Well,
if that's what she wants, if that's what the court wants.
I'm in a situation where I'm being asked to make a decision based upon evidence that I don't feel is sufficient at this point.
And we request a continuance. I think maybe we need 60 days to get that subpoena.
Ma'am?
Like I said, I have
just wanna remind you that you're under oath.
I have grandchildren living
Okay.
with me. I'm not doing it, I'm dealing with so many other things. My roof is leaking,
It's
like
fine.
this is just, you want to find me, I think $15,000 is insane because it's been 10 years since the first time, and, I'm over this, or, I'm over the short-term rental thing. Personally, I wouldn't want it on my block. I've learned that. I think owner-occupied is something that I could see coming. I have rentals in Seaside Heights, New Jersey, and it's a disaster. We want no part of it. I wouldn't bring people into my home while I have grandchildren there. I mean, that would be insane. And that room is in my house. It's not like an apartment or anything else. And as far as neighbors complaining, if you had the proof that there was a
We'll get it.
short-term
We'll-
rental, you would have busted me back then. But I have lots of company guaranteed, from places, but
We plan to subpoena the records to show if she lied under oath, and we'll hear it in 60 days.
Ma'am, does
And
that?
again,
that's fine.
I want to make
you
a
know.
decision based upon facts that I can feel comfortable with. And I feel that there are things that are being said that some of the things are unsubstantiated. Now, clearly, there is a posting, and your name is associated with the posting, okay?
As a
But
property
then-
manager.
It's proper. But I think the best way is for the city to sit down and think about presenting this in some fashion. And maybe when you get through, we've got all this citizen complaints. You can talk with Ms. King about that.
Oh, I would definitely like to see that.
Exactly. And those things are important, but it's just because somebody says that somebody complained, that doesn't mean anything to me at this point. So what I'd like to do is, Ms. King, if it's agreeable with you,
I would not like to have to hire a lawyer. I don't really have the money for that, but if I have to come back, I will have to bring my lawyers. And, if you want to throw a fine on me, throw it on me and get it over with.
your prerogative.
I don't want-
50,000 is crazy, you know what I mean? And all that hearsay stuff in between, if you could have, you would have. But, I just want this over with because I have other things that I'm dealing with much
Well-
more important.
what I'd like to do is continue it for 60 days. Is that acceptable?
I just want to get it over with. I really just want to get it over with. I have serious things, and this is ridiculous for me to have to spend money on a lawyer.
Yeah, if $15,000 fine is not amenable at this time, we request a continuance for 60 days to show the evidence to support our argument.
Okay. Well, At this point, the city has requested a continuance for 60 days. And hopefully,
Going to need more than 60 days. I'm going to need at least 90. I have somebody that's terminal.
If you want 90 days, we're fine. Give us more
90
time to get
days
the
is
subpoena
fine.
records.
I just want to see this brought to a close so that I feel comfortable with whatever decision I make. So,
You okay with 90 days?
Yeah, absolutely.
okay.
We're fine with 90 days.
Okay, so therefore, case number 5, RTL 05-2530, the respondent being Joanne DeBaron King. This case will be continued for 90 days to whatever that would be. What date would that
Would
be?
be, so what's today? 1, 2,
I'd also like a copy of
the
the
April?
against Maple
1, 2.
waivers.
We could
You'll
put,
have
you
to
could,
make a formal request for the.
no, we'll get it to her. Just give him your
Whatever you're
email.
entitled
I'm
to,
sorry.
ma'am.
Give him your email and he'll get it to you one.
Okay.
I think that's August 20th? I'm doing the math right?
26th.
August,
I do
yeah.
know that I still do, so please make sure to give it to
Okay.
me.
This,
Let me write it down for you.
Okay.
And the reason the Airbnb has been deactivated is because I can't travel on it anymore either.
I've never seen the Airbnb, so.
okay, so this matter is continued to August 26, 2025.
Okay. Am I dismissed? Can I go?
Yes, matters. Hopefully we'll see you in August. Hopefully you get resolved before then. That's what I'm hoping for, so that we can bring this to a close. I understand your arguments, I understand the city's arguments. And I don't,
Yeah, he was there that day to take pictures of, after some of them
And
first, and he was in my house, like right after I wrote my dog from that.
okay.
Taken down the same day, which you had control of the listing.
All right, we'll move on to our last case, case number 6, RTL 05-2531, Jura Whaletail Group LLC, cite for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 552 Wells Street. If you could state your names and be sworn in, please.
Lori Bossy Lane.
David Lang?
Lauren, can you state your name again for me?
Lori,
Lori.
and it's Bossy, B-O-S-S-E dash Lang, L-A-N-G-E.
Okay, thank you. All right, if you both can raise your right hand. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned RDM5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed May 7, 2025, and they were notified the same day. The property stopped actively advertising as of May 16, 2025. The daily posted rate was $265. The advertised rules show a check-in, check-out time of 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz?
I'm sorry, I do have one question. Are you the owners,
We're the managers.
managers?
Do you have authority to speak on behalf of the owners?
Yes.
Okay.
Were you present earlier when I read the city's position? Would you like me to reread it? No? Your Honor, we just request that the city's position about this, the nature of this being irreparable and irreversible, be read into the record.
Okay. Let the record reflect that the city's statements regarding this type of violation being irreparable and irreversible, as stated in case number 7, RTL 042521, be incorporated into this proceeding, this particular case. And as I have told every other respondent, if you object to their, in any way to their arguments as to these being irreparable and irreversible types of violations, this would be a time for you to make such comments.
I guess we had the advantage of seeing all the other cases, so.
Yes, you did.
What I would say is I just want to remind Kevin, I know it's very tenuous in here right now. Everyone take a deep breath. The reason there was such a gap between when we were, well, the notification, we don't live here. We're don't live here. So we didn't see it, the posting. And when it was mailed to our mailing address, we moved. So we didn't get anything. So when I did get it, I called him immediately, and it was actually taken down before that because I was like, oh my goodness. We were just unaware. And what I also want to bring forth is a couple of things. If you guys have been doing this for 7 years and you're still doing it, you're doing something wrong, I would say. The fact that you're just now contacting Airbnb or VRBO or any of the
We
other
don't have the
ones-
resource to subpoena on every case, and it's properly posted. We can't control that people break the law.
I guess
No,
I just
that's
don't
why we have-
understand
I
why
would
when you
think
go to
the-
Airbnb, you're allowed.
Oh, they haven't been
No,
willing
they
to
do.
block
I
that.
talked to them. So
They haven't?
No.
Airbnb
That's
has
what-
a,
Something
that's
is
what we thought.
nonsense.
Yeah.
That would make sense just to put up a geofence around the area you
Right.
can't.
Airbnb is.
Because no one knows
I-
that. No one knows
yeah,
what your zoning
Airbnb is-
is. I
I'll
asked
let you
for
finish.
it.
Yeah, I'll let you finish. Airbnb, I spoke to their legal representative. They say that they have a waiver that all people sign, well, not sign, but they like check a box, whatever, that says they are not responsible for the laws in that area, that you have to check. They have a disclaimer, and I don't know if you read the fine print, but that disclaimer is there that says that they aren't responsible for giving you the authorization in that area. All companies, Verbo does it. So they are a big corporation, and they don't have the resources to go in every little neighborhood to see if they can do it. They don't have the resources. We have one person. Some of these people know, right? The previous person, they were on notice and they continue to do it. And I understand where you're coming from, but we don't. How else should we advertise it?
I
We
don't
post a
know.
law.
I just think someone should
you
do
know.
some solid thinking
we thought we
through the
did our-
process of
we-
how to educate people, because literally that's what we bought it for. I was so excited because I had one down in New Smyrna.
Yeah.
And I had to end up selling it, but that's.
Hey,
that's
I'm
irrelevant.
open to
I mean, I was excited
suggestions.
to be next to the beach and be able to stay here. So I'm sort of sad that the dream is going to die, but I understand that we can do this out like in South Daytona, that they allow it. I'm not sure why they allow it and you guys don't.
We allow certain rentals. He can give you more information on what you can do for long term, but 3 months
Yeah,
a
I
day.
can always show you guys the interactive map we have too, where you can
You
see.
did.
But okay,
I
yeah.
asked
but
you for it. You
oh,
gave
that's
it to
right.
me, 'cause I
Okay,
was
now
like,
now it's
now,
ringing my bell.
okay,
But-
I'm that person.
But yeah, just to bring everything back, I will say, to my knowledge, the minute they actually got the notice, they did cooperate immediately, and there were no issues past that.
Right, what you've stated here, from previous times
Yeah.
that you've appeared before me, is consistent with somebody who's acted immediately.
Yeah.
Or as close to immediately as they can. Let me say two things. First of all, one is that when I first started hearing these matters, I think it was around 2019, or goes back a ways.
2016.
Yeah, 2006. Yeah, we tried to make contact with VRBO, or the city did, to block out areas where it's not, and they just adamantly refuse. You would think that in this age of computers that they could do that, but there are, and there's also, it's just been something that unfortunately is an ordinance. Now, the other side of the thing I wanted to mention is that all of this could have been resolved with a nice statute, but the legislature refuses because all this stuff, what the city has, the city is in a grandfathered position. And so the city essentially, because there is another statute that says if you change your ordinance after this date, you lose the ability to regulate it, period, completely. And so it's a confusing mess that could be made simply by the legislature passing a law, and they've tried several times. They never seem to ever follow through on it. And so that's the situation we're at. But different communities have different, in some communities, you can go out on the road. In some places, you can go 50 miles an hour. In some places, if you go 50 miles an hour, you're going to get a speeding ticket. There's different rules in different areas and different communities, and that's just the way it is.
Do you mind if I ask, the realtor who sold you the home say that it was okay?
No, they didn't. I didn't ask. I didn't even know to ask. So I didn't ask the question. They didn't tell us. So
We have a number of properties that we do long-term rental for. This was the only.
right, this is the only one that we're going to do that with.
We've had people come before us who went to the county, which has a bed tax, which I believe should be administered on those, and they'll collect the money. I don't know why. They won't say like, well, you're in Daytona Beach, you can't do it there. They just collect the money. I can't explain. Nobody's talking to anybody or whatever. And I know the city has tried on many occasions to get the word out to realtors groups, to property management groups, and yet
That's why I asked. I want to see
we're
if maybe I
still
have to reach out to
hearing
them.
cases.
Yeah.
Yeah. And then I guess my other thought would be that at least the majority of what I've seen here is that everyone was very compliant very quickly. And what I would say is it just kind of leaves a bad taste in your mouth when the city wants to fine you right away instead of giving you a warning. Because to me, if you're given a warning and you comply immediately, I don't know why you're being fined. That feels like a penalty of that you continue to do something you shouldn't have done. So what I would say is I think the city should probably, it would be nice if they would revisit the fines. That feels like the city just wants to make money off people, because I mean, literally, I think several people in here are in the same boat that we were in. Didn't do it maliciously, didn't repeat, they just complied. When they were told, when they were warned, they complied. And so I just don't feel like a $1,000 fine is a fair thing to do to someone who doesn't know, and doesn't even know the law to ask that there's a law.
Can I ask you a question? Mm-hmm. Have you ever lived in a homeowner association or had a property in a homeowner association?
I try not to.
Why?
Too many rules and regulations.
Exactly, because you have to check with the homeowner association before you do anything, right?
Well, no, you usually find out after the fact that you painted the wrong color.
Well, that same rule applies to cities, right? People don't like homeowner associations because there's rules they have to check, and they know that there's rules they have to check. And similar to a homeowner association, there's rules that we have to check, right? So, could have called. And that sort of.
The Florida Supreme Court has held that you are responsible for knowing the laws, and if you're engaged in what amounts to a money-making operation, that's probably even a stronger incentive to know what the laws of the local jurisdiction are.
True, but you don't really know what to ask for when you don't know what's. I don't know. It's obvious that the normal person doesn't know. That's why you're sitting here, and you've been sitting here doing this for 7 years. The average person doesn't know. So
there are many fewer people here now.
That's good.
Than there were years ago. The word has been getting out. It's just that there are some folks who are at the end of the line who apparently haven't found out yet.
I looked at his zone very close. I'm like, oh, so I am 1.7 miles away from where I could have done it. Oh, but see, that's what I'm saying is that average people don't know exactly where that line would be or wouldn't be or whatever. I don't know. It is what it is. But
okay.
I can be looking for something.
Thank you for taking it down as soon as we appreciate your compliance.
Okay. The city has asked that a fine in the amount of $1,000 be imposed. And are you making any statements in objection to that?
I am. I don't like it.
Oh, okay. Understood.
Let's get you to your doctor.
Is there anything further?
No, sir.
Okay. Therefore, in case number, I hereby find the respondent Jira Whaletail Group LLC in case number 6 RTL 052531 as the owner of the property at 552 Wells Street to have been in noncompliance of Article 4, Section 4.1a and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time that the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes, and the property has subsequently been brought into compliance on May 16th, 2025, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and if for any future repeat violation, the respondent may be placed on subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. Is there anything further?
You'll get instructions in the mail. It'll be about a week and 3 days.
Yeah, because we don't live there anymore.
It's a lien on the property. You don't have to pay it right away.
But, yeah.
But yeah, absolutely. If you want to give it to me.
14604. 04? Bray, B-R-A-Y.
I know you'll talk to you later about that. Okay, yeah, absolutely. You just let me know.
Okay.
And I'll get cracking.
Thank you.
You're welcome. Okay. He still has to
Apologies.
close us.
My apologies, Your Honor.
Is there anything further?
No, you're on.
Okay. It being 11:10, I hereby call this proceeding to be adjourned.
I'm never good at judging how long these things are going to take. I'm like,